Good afternoon. Thanks again for joining us for yet another Federalist Society debate. This one is entitled Bilski vs. Kappos, How Should Courts Handle Intellectual Property in the 21st Century? As you well know by now, my name is Aman Sharma, and it is Hispanic Heritage Month, and John Templeton Foundation is providing us with the food today, and we hope you'll enjoy the Chipotle. In honor of that, of course, me llamo Aman Sharma, soy el presidente de los Federalist de Moritz. We should have the jerseys would say like Federalist or something instead of Federalists, but we don't have to go that far. Anyways, this debate, of course, is part of the John Templeton Foundation's debate series on the rule of law and wealth creation. Very pleased to be working once again with the John Templeton Foundation. Today's event focuses on a somewhat technical topic. It's Bilski vs. Kappos, the recent Supreme Court case, which discussed the finer points of the machine or transformation test. The debate is designed, however, to cover a little bit broader range of intellectual property topics, and so we certainly hope that you're not going to feel intimidated by the subject matter. Before we begin with the introductions to the speakers, I'll give you a quick update on our schedule and format. Normally we do the 12 minutes introduction with a 10-minute rebuttal time, and then we take questions from the audience. In this case, because the subject matter is a little bit more technical, we're going to afford our speakers a few extra minutes to explain the subject matter, so please be a little patient with us on that. Now, we'll begin with the introductions to the speakers. Professor Grant practices law with the Stanford Law Group in Dublin in the field of intellectual property. He's a chemical engineer by trade and also a lawyer. His most particular expertise is in the prosecution of U.S. patent applications that originate in foreign patent offices. Professor Grant has been admitted to practice for more than 20 years in the United States Patent and Trademark Office, the Supreme Court of Ohio, the Northern Ohio Federal District Court, and the Federal Circuit Court of Appeals. He's been a frequent speaker at continuing legal education courses, as well as at general education presentations for inventors, writers, and artists. He's a regular contributor to the newsletter of the Ohio State Bar Association Intellectual Property Law Division. He has taught at a number of law schools around Ohio and is noted for his teaching ability. That's why we picked him up here at Ohio State. And Professor Michael Risch is a professor of law at Villanova University Law School, located near my hometown of Philadelphia, although sadly he is not an Eagles fan yet, but hopefully his kids will be. Professor Risch's teaching and scholarship focus on intellectual property and cyberspace law, with an emphasis on patents, trade secrets, and information access. His articles have been published in the Indiana Law Journal, the Brigham Young Law Journal, and the Tennessee Law Review, the Harvard Law Journal of Law and Technology, and the Yale Law Journal Online, among many others. He served as an Olin Fellow in Law at Stanford Law School, and was a partner at intellectual property boutique firm Russo & Hale, LLP in Palo Alto, California. Please welcome me and joining first, Professor Risch.
Hi, thank you. Okay, hi, thank you for having me. My children will not be Eagles fans. I have anything to say about it. We may allow them to root for the Phillies. They're young enough to mold that way. So I want to talk about Bilski. Interestingly, patents are considered high-tech, but there could not be a lower-tech patent. It's interesting, the title of this is How Should We Consider Intellectual Property in the 21st Century, when in fact this is very 20th century and even some 19th century type of technology, a little bit, but with a computerized flair. So let me tell you first, the ruling in the Bilski v. Kappos case was very simple and short. Abstract ideas are unpatentable. This was not new, this was not earth-shattering. In O'Reilly v. Morris, in the 1850s, the Supreme Court said abstract ideas are unpatentable. So why did it take a Supreme Court ruling here in 2010 to say what we already knew from more than 150 years ago? How did we get here? Well, I'm going to tell you. There were 3 software cases back in the 70s that really shaped how we think about patentable subject matter for software. And The interesting thing is, Bilski is not really a software case, and so I want to explain to you what these cases are about so that you can understand why it is that these software cases should have anything to do with something that has nothing to do with software. But first I want to say something about patentable subject matter. The idea of patentable subject matter is this. Is there a class of patents, no matter how new, no matter how non-obvious, no matter how useful, that we just will not allow? That's the question of patentable subject matter. It is a categorical exclusion unrelated to the merits of the patent, at least theoretically. And so, in these three cases, the court looked at this question. The first case was called Gottschalk versus Benson. And that was about, it was an algorithm done in a computer where numbers were converted from binary decimal code to pure binary. An example of binary is basically ones and zeros. The one I'll use is a recent one. A couple of days ago was 10, 10, 10, as some of you may have seen. People were all excited about this. It turns out that 10, 10, 10 is binary for the number 42. If you're a math or computer geek, you know that. And if you are a super nerd, then you also know that that is the meaning of life, the universe, and everything in it. And the court said that this method for converting, which you could do on paper, was well known, but these were the first people theoretically to do it in a computer, would preempt a fundamental principle of nature. And the basic rule people think came out of that case, although it's unclear, is that abstract ideas, algorithms or abstract ideas, are not really patentable. The next case was Parker versus Fluke. And in that case, it was a method for adjusting an alarm limit in a catalytic converter. Sounds complex, but it's not. The idea was, if the temperature gets over 200 degrees, sound an alarm. Oh, wait, we need to adjust it. Let's make it 201. Okay, sound an alarm if it's 101 degrees. And this obviously is nothing new. There have been alarm limits if things get too hot. You might know this, thermometers. However, the way that the alarm limit adjustment is calculated was a theoretically new algorithm. And the court said, if we consider this algorithm to be part of nature, then there's nothing new in this invention. And so Fluke does not get a patent. Finally, we have the case of Diamond versus Deere just 3 years later. And this was a method for curing rubber, using, again, a well-known algorithm. This one was the length of time it takes for rubber to cure under certain temperature and pressure conditions. And so the invention was to constantly measure temperature and pressure, recalculate the curing time, and then cure the rubber for that amount of time. Not rocket science, but they were the first ones to do it via computer with this constant updating of the time it would take. But this time, the Supreme Court said that is patentable subject matter. That, if we look at it as a whole, is new. It doesn't matter that it used an algorithm, even if the algorithm was well known, because as a whole, this was something new. The problem with these three cases is, how do you tell the difference between something that's not patentable and something that is? How do you tell whether or not an algorithm will nix your patent or whether it's good? That's an answer we're still trying to find, and it's an answer they were trying to find in the Bilski case. After Deere, the general view was that software patents were allowed. And in fact, we saw a great rise in software patents. But increasingly, there was a move away from industrial software patents like curing rubber to data processing patents, what some would call business methods. In the 1998 case of State Street Bank, the court looked at a method for calculating mutual fund returns, where basically what the program did was looked at a bunch of satellite investments, figured out how much they earned that day, added it together for reporting. This was important. Before this invention, you couldn't do the type of investment vehicle that you wanted to do, but it required a computer to do it. In 1998, the Federal Circuit said, you know what? I know people have thought for 100 years, or we know people have thought for 100 years, that business methods like this are unpatentable. But you know what they really are? They're patentable so long as they reach a concrete, useful, and tangible result, and this does. And therefore, business methods are patentable. The State Street Bank is widely thought to have opened the floodgates to business methods patenting. And so we saw a rise in patents like the one-click patent for Amazon, where you click one button and your stuff gets shipped to you, and patents on reverse auctions like Priceline, name your price, etc. But an interesting thing happened after 1998. Patentees, seeing that business methods are patentable, said, well, why does the business method have to be tied to a computer? Why can't it just be a method for doing something that's not tied to a computer? So increasingly you saw patents that were divorced from computers. There's a patent, for example, on how to pick up a box. You bend your legs, you pick it up, I swear. There's a method for exercising your cat. Take a laser pointer, go like this. I think it's even a flashlight patent. And the cat jumps around at the light. And here is where Bilski comes in. Bilski claimed, the broadest claim, hedging. Buy from one, the claim is literally this broad. Buy from one population that's willing to pay a high price. Sell to another population that's willing to buy at a high price. I mean, who's willing to sell at a low price and sell to somebody who's willing to pay a high price. That is, buy low, sell high. You've probably heard of this before. It's the way you make money in the stock market. This was it. That was the claim. Now, they had some other claims, like the particular way to figure out the pricing, some particular statistical test that you run, which you don't need a computer for, but you would have to have practically the statistical tests run calculations some 100,000 times. You probably want to do that with a calculator or pencil and paper. They also limited it to certain types of data and later claims like energy, but the broadest claim was exactly that. Buy from one population with one risk profile willing to sell to you at a low price, and sell to another population with a different risk profile who's willing to buy from you at a high price and make money in between. When I was in school, we called this arbitrage. Now they call it hedging. The key is that you didn't need a computer to practice it. And so the interesting thing is, all of the cases that applied were about software, but this is not really a software case. And in fact, that is where the Federal Circuit came in. When the Federal Circuit ruled on this patent, they came up with a test called the machine or transformation test. And they said, here's how we read Benson, Fluke, and Deere. These three cases I just told you about. If your claim is tied to a machine, or if it transforms physical matter, or if it transforms data relating to physical matter, then it is patentable. And that is the only way it can be patentable. If it does not satisfy that test, then it is not patentable. Now, the problem with this test is manifold. Number one, it draws the wrong line, this whole machine idea. Why? Well, look at Benson. Benson was implemented in a machine, and it wasn't patentable. Fluke was implemented in a machine, and it wasn't patentable. So how is it that if you pass the machine test, you're patentable, when in fact Benson and Fluke were in machines? Now, the way you get around that is a rule they call the insignificant post-solution activity rule, which is, if we think the machine's unimportant, we can ignore it. Now, the problem with that should be relatively obvious. How are we supposed to decide whether or not the machine is unimportant? That's another problem. So there's two problems. Number one is it's the wrong line to draw, this machine line. Number two, it's overly vague. We have no idea how to apply this insignificant post-solution activity. Number three, it's rigid. That there is no other way. Now, the doctrinal problem with that is the Supreme Court, in announcing its opinions, actually said we do not want a rigid test. This is back in the 70s and 80s. Yet they ignored that in the Federal Circuit. And being rigid is overly restrictive. It is undoubtedly going to